Good afternoon, Judge Masipa.
Afternoon, Chief Justice.
How are you this afternoon?
I'm well, thanks, Chief Justice.
Yes. I have disclosed to the commissioners that many years ago you were my clerk stroke researcher. I think it must have been around 98 to 99 or 2000. Is that correct?
Yes, that's correct.
Yes. Thank you very much for availing yourself to be interviewed for a position in the Supreme Court of Appeal. We appreciate your availing yourself. I'm going to ask you some questions, and commissioners will ask you some questions. All our questions will be directed at us getting information that will enable us to see how you fare in terms of our selection criteria that we adopted earlier this year.
Yes.
All of us will be asking you questions with a view just to look at that. We might be robust, but nobody will be asking you questions with a view to humiliating you or treating you with disrespect in any way.
Yes.
You understand?
Yes, I do understand.
Okay, all right. Well, I do know that when I interviewed you for the position of a clerk, law clerk or researcher, you had been a student at the University of Natal. Is that where you did your first and second degrees?
No, I first did my BProc degree at the University of the North, now University of Limpopo. And upon concluding that, I then went to do my LLB at the University of Natal.
Yes. And subsequently, you also did an LLM at the University of KwaZulu-Natal, is that right?
Yes, that's correct.
Was that in 2015?
Yes, it was awarded in 2015.
Yes. At the time that you finished at university, you were not thinking of following the legal practice route, is that right? You didn't think that you wanted to practice law, is that right?
Yes, at that time, but prior to that, and when I obviously registered for my law degree, I had intentions of practicing, but then I don't know what changed somewhere along the way. It seemed like the life of legal advisors were easier, I guess, to me, and I thought that was the option that I would take.
Yes. You practiced for about, was it about 16 years before you were appointed to the bench?
I think it's slightly below that, Chief Justice, but I did not work it out now, so I cannot give the precise number.
Yes, but it's more than 10 years.
Yes, it was more than 10 years.
Yes. And was your practice in Durban?
Yes, it was in Durban.
And in terms of a variety of work, how diverse was the work that you were doing?
We did a lot of, I first practiced in a biggish company. There was about 4 directors and, a number of associates. So we had different departments that were running in the firm. I did mainly labor law, and I did some maritime law work. And then we after a couple of years, split the practice, and I went into my own firm, and then I did some commercial work, continued with the shipping work and the labor work.
Yes. How many years have you been a judge now?
This is my 8th year.
8th year.
Yes.
In the High Court, have you been involved in criminal trials, civil trials, criminal appeals, civil appeals, motion court throughout?
Yes, I have. I think we have. I like the way that our court operates because it exposes you to everything at almost about any given point in time. We have a system where almost every Friday you're sitting in appeals. That would be appeals from the magistrate court, and sometimes at the beginning of the sessions you'd have the full court appeals sitting Mondays, Wednesdays, and Fridays. And that's in between that you have motion court, you have civil trials, and you have opposed applications. And that's when you're in the civil court. So you move every session. Then when you're not in the civil court, you're in the criminal court. You obviously running criminal trials, but you still do appeals. And when you're doing appeals, you're not limited to doing civil appeals or criminal appeals. Whichever appeal is allocated, then you attend to that.
Yes. Have you had the opportunity of dealing in either in the High Court or in the Supreme Court of Appeal when you were acting there, with cases where the court is asked to declare legislation constitutionally invalid?
There's a matter that I dealt with in the High Court, not in the Supreme Court of Appeals. Well, come to think of it, it was not necessarily legislation, but that's how it was couched, that I declare a specific rule or regulation constitutionally invalid. It involved with a certain rule which is applied by private schools infringe on certain rights in the Constitution. That's the right to education I think it was the right to education, but then in exercising, in dealing with the matter, I also looked at the issues relating to the interest of the child who was involved in the matter. They had sought for me to declare that constitutionally invalid.
So was that the matter of Lena, who was denied the opportunity to write exams?
Yes, that's correct.
Okay. So you were not asked to declare legislation constitutionally invalid, but you were asked to declare some regulations applicable at the school?
Yes, not at the school, but it's in respect of private schools.
Oh, okay. And what was your conclusion?
Well, I concluded that it was invalid, but then obviously it did not obviously take the step that when you declare a legislation constitutionally invalid, it would follow, because ordinarily once a legislation is declared constitutionally invalid, it has to obviously be taken to its operation would be suspended, and or some other interim measures be put in place whilst the matter is referred to the Constitutional Court for the Constitutional Court to actually confirm that declaration.
So it was not legislation, it was some regulations.
Yes.
But did that matter give you an opportunity to know what the approach is that a judge is supposed to adopt when determining whether legislation is inconsistent with the Constitution and invalid, or
Yeah.
did it not give you that opportunity?
Well, I believe that it did. Yes.
What is the approach?
Looked at, as I said, that I had to consider the rights that were there in respect of that child. So you look at the legislation, the impugned legislation that is thought to be declared invalid, and then you look at the right that it infringes on, and then whether that legislation serves a legitimate government purpose. And then you balance the rights, looking also at the limitations clause in terms of Section 36 of the Constitution.
There are two types of discretion. Are you familiar with them? And if you are, what is the difference between them, and what is the legal significance of the difference between them?
The two types of discretion exercised by a judge is there's a narrow discretion and there's a wide discretion. So in respect of the narrow discretion, you are limited to or confined to the rules, the statutes, or the regulations that you're dealing with or focusing on in respect of that matter. And in respect of the wide discretion, you have flexibility in terms of how you exercise that discretion.
How many acting stints have you had in the Supreme Court of Appeal?
As of yesterday, on my fourth stint.
On your fourth stint?
Yes.
And when you put all the months that you have been there together, about how many months does it come to, more or less? A year? 4 terms?
No, it's not yet 4 terms. I started yesterday my 4th term. My appointment started yesterday for the 4th term.
But you have had 3 terms?
Yes, I've had 3 terms.
Oh, okay. You are on your 4th term?
Yes.
Oh, okay.
So when I count the months, they work out so far to about 9 months.
Yeah, if you say 3 terms, that gives us an idea. How was your first stint, acting stint in the Supreme Court of Appeal? How did you enjoy it?
I did, but it was obviously a different environment for me, with a different court, different ways of doing things. So it was a learning and challenging experience. Yes.
I assume the second stint was much better.
Yes, it was.
Yes. And the third one, are you close to cruising?
Well, I'd like to believe that, but it's always a subjective view. You may see yourself, in a certain way, and other people see something different. So, yes.
Oh, okay, all right. I will now allow the Deputy President of the SA to put questions to you.
Yes.
Thank you, Chief Justice. Good afternoon, Judge Masipa.
Afternoon, Judge Betsa.
Your last acting stint at the SAA was in May
Yes, that's
this
correct.
year. I see from the comments of the GCB that they say you possess extensive experience in the field of labor law, as well as experience acting in the Competition Appeals Court, and that you would make a valuable addition to the Supreme Court of Appeals bench in those areas of law.
Yes,
Did you see
saw
that?
Yes, I saw the comment.
But what seems to have been lost on the GCB is that the SCA doesn't have jurisdiction in labor law matters, nor in competition appeal matters. Those go to the Court or Constitutional Court.
Well, there's certain types of matters, employment law matters, that that have gone and still go to the High Court, and appeals of those matters would come obviously to the SCA if taken, and not through the labor and labor appeal court system.
But ordinarily, the labor court is a specialist court and it has exclusive jurisdiction.
Yes, that's correct.
Then, for its part, the Law Society of South Africa recommends that you do well with more acting stints.
Yes.
They say you should be given more opportunities to act in the SCA, to develop yourself, such that you would be able to present yourself as a strong candidate.
Yes, I noted that.
Yes, and what's your response, if any, to that?
Well, I obviously don't know the reason why they're saying that. I think it was about the issues of the judgments. I think when I recall that the judgments that I submitted were the ones that were co-written with other senior judges in the court. Well, in addition to the judgments that I submitted, there's, well, in my view, there's judgments that I have not submitted, which some of them came after I had submitted my application, that although I co-wrote them with other colleagues, I played a major role in the ultimate outcome, and I can about say, confidently to myself that I own those judgments. The fact that my name appears with someone else does not necessarily mean that I do not know how to do my work. As is apparent from the other judgments that I submitted, although not in the Supreme Court of Appeals, most of them are appeal judgments that are submitted. In the Supreme Court of Appeals, the judgments that I can say I'm claiming, and although there were other people that I co-wrote with, it's about 8 judgments. I have I have the ability and the confidence of standing as an independent person, and hence some of those judgments are matters where there were dissenting judgments that I either wrote or I played a major role in their being. So and in addition to that, the other matters where my name there are matters where my name does not appear as somebody who co-wrote a judgment. Because to me, when a matter comes to court as an appeal matter that has to be determined, it is not about my name appearing as a scribe of a judgment, but it's about the ultimate decision that is arrived at by the court, being the 5 judges or the 3 judges that would have been sitting there. So no matter how much of an effort or contribution I play in those matters, I have not said to people, because of this contribution that I played in the matter, my name must appear on that judgment, despite the fact that I would have played major roles in those judgments coming out. So when a judgment comes out, and out of the 5 judges, my name appears there, I'm happy. I take pride in that, and I'd know that I did all that I had to do to make contribution to that judgment coming into being. I guess I don't know. Obviously, people who do not get involved in writing appeal judgments would not know what involvement the judges get to do.
Would you care then to enlighten this commission on how it came about that judgments that were initially allocated to you as the sole scribe ended up being co-written?
Okay. So
with a senior colleague?
Of the I think it's 4 judgments that were submitted as part of the pile of my records. There's 2 judgments that were initially submitted, allocated just to me. The one is the RAF matter that I co-wrote with Judge Govan. That was I think the first matter that I dealt with when I went into that court, and I had obviously prepared a draft, and I spent some time with Judge Govan getting his views and his inputs, and somewhere when we were about finalizing the matter, he said to me, I'm of the view that I've contributed a lot in this judgment, so my name must appear. And well, I don't know if I could say yes or no to him. So he's a senior judge and he's telling me that. And I'm not going to say that he did not contribute towards that judgment being written. But similarly, as I said, I've contributed to other people's judgments in the same way that he contributed to my judgment. But I never said to them, my name should appear in that judgment because of the contribution that I made. Because to me, in my view, that matters. I was allocated to that judge, and as long as my name appears as one of the 5 judges who had written the judgment, it was enough for me. The second matter.
Perhaps before you go to the second matter, insofar as that one is concerned, what got to my ears was that because of the substantial contribution that he made to your draft, that was the reason why it was thought that it was only fair that his name should also appear as the co-scribe.
Yes, I did say that. I don't know if you missed that. I said I accept that he did make a substantial contribution.
Yes.
Yes, I think, let me leave it at that. I'm not disputing that he made a substantial contribution. What I was saying was I've made similar types of contributions to other people's judgments, but I never said to anybody my name must appear on that judgment. I'm not saying he was wrong to do what he does, and then I accept that he had the right to do that. So should I proceed to the second matter?
Then there is another judgment that I allocated to you and another permanent judge,
Yes.
who subsequently reported to me that the 2 of you had agreed that you would be the sole scribe and wanted to find out whether that met with my approval, which I endorsed.
Yes. So I think it's the discovery matter. I did a draft of that judgment. I gave it to, circulated, well, she said to me before I even circulated, give it to me for me to have a look at, and then I'll discuss it with you. Then I did that. She made some input to the judgment, and I looked at them and considered them and added or amended where it was necessary. And then I circulated the judgment to everyone, and she and the other judges put their comments, which is, ordinarily what my expectation is what's happening, in the court. I worked on it, and all of them were happy with the draft that I ultimately had. And then I think it was with you then, we were waiting for you to comment on it. And then you were not happy with how some of the, how it looked. And then you then took upon yourself to work with me on it. But then the three other judges that had received the judgment were happy when I gave it to you.
But for your information, I can indicate to you that they hadn't read your draft before I got involved, except for one of them, and then produce the final judgment together. And that was the MEC Police Roads and Transport Free State.
So, okay, so it means it's three judgments. You're talking about a different matter, and I'm talking about a different matter, because I said I'm talking about the discovery matter. I was talking about the discovery matter. The MEC matter, I did get comments before it came to you. And in a similar vein, I worked on the comments, and I think, I'm not sure if it's the one that Govan was involved in. If it was, he was the only person that had not commented other than you. The other two judges had commented. I had worked with them on their proposed amendments, and they were happy when it came to you. When you spoke to me in respect of that MEC matter, that's the reason that you gave to me as to why your name is to appear on that particular one. There was an issue about the application of, the manner in which that particular matter was referred to the High Court. And when we were in court, counsel was asked, do you think that this matter deserved to be here in this court instead of the appeal being dealt with in the full court? And counsel had accepted that it did not justify being in the Supreme Court of Appeals. And then I had written, as part of the judgment, why that matter should not have come to the Supreme Court of Appeals, and stated that should the High Court in future refer matters which were not befitting, then the court would take the necessary action, I think, in terms of section 16, and then you said, because of the comments that, the serious comments that are being made in respect of how the judges of the High Court deal with matters, it would sound better if it's coming from a senior person from the Supreme Court of Appeals and not from you as a judge of the High Court. So, and you said that's the reason why it is necessary that your name appear as a co-scribe in that particular judgment. And that was the reason that was given to me.
Are you suggesting that I made no substantial contribution
to the
final product?
Definitely not. I'm not saying that you did not make any substantial contribution.
Okay, then there's the third judgment which is in fact discovered.
Yes, I started, when I moved from the RAF matter, I said the next matter was the discovery matter, and then I dealt with the discovery matter. And then when you said to me, it's the MEC matter, I said, no, I had been addressing the discovery matter. I had not been addressing the other one.
Yes. Okay, but that one was, we were the designated scribes right from the outset,
Yes,
you and I.
yes.
During the last week of May, and I'm duty bound to say this, of your own accord, you approached me, indicated that you are aware that the SCA had advertised and that you would not be making yourself available for those positions. And I see from the questionnaire you signed the form on the 19th of June 2023. What happened that caused you to change your mind in less than a month after you had indicated to me that you need more acting stints? In fact, that's the reason why you have been invited back in November.
Well, as far as I remember, when the talk that I had with you, I said to you, I'm aware the positions have been advertised, and what are your views in terms of that? And then you said, you, in your view, I should be given more acting stints. So yes, and then you said, well, when that becomes available, an opportunity, then you'd be invited. Because in fact, I think before that, you had indicated your intentions to get me to come back. I think it was supposed to have been that the June term but then there were obviously some issues or some changes there which led to that not happening. But then in considering, I guess, I looked at the time that I spent there, the need, the views that I formed about how certain things were happening in the court, and I thought I could make a contribution to the court.
But you didn't find it necessary, just as a matter of courtesy, to say, don't be surprised to see my name in the head. I've changed my mind.
I think when I was next to you, although you yourself said that it was not easy for me I do not go into the office and I'm not approaching you, and I indicated my reasons to you why. So when I was away, it got worse. In that same vein of my respect of authority, I do not, unnecessarily burden when I feel, unless I really have to be doing that.
Thank you. I'll leave it there. Thank you, Chief Justice.
Thank you. Minister?
I'm fine, CJ.
You are covered.
Yeah.
Commissioner Tutovu?
Thank you very much, CJ. Good afternoon, Justice Mali.
Masipa.
Oh, Masipa, sorry. Sorry, Masipa. I'm covered.
No, I understand.
I'm covered,
you were
CJ.
expecting
I'm covered. One day I'll tell you why I'm covered.
It was the wrong script.
Oh, Commissioner Jojo, do you want to use this time?
It's okay, it's okay, it's okay. I'm
You're covered.
It's covered.
Oh, okay. Oh, you'll tell her some other time.
I'll tell you.
Okay, all right. Commissioner Marumuahai.
Thank you very much, CJ. Good afternoon, Judge. I'm
Afternoon,
here.
Commissioner.
I'm here.
Oh, sorry. It's because when I was looking there, I saw the hand and I
Yes.
didn't tell. I apologize for that.
When you get a chance to be a judge in that court, and you are one of the judges who are doing duty and looking at the applications for appeal to that court, and you find that there is an application that was brought, but it was brought out of time, because a lot of things can happen sometimes. I mean, think about maybe a civil matter where it was decided last year in November, and it so happens that the lawyers involved, they got out of the matter and the matter died, but somebody picked it up and they convinced the litigant to appeal. Under those circumstances, what application ought to have been made for the Supreme Court of Appeal to hear the matter, and what is the test that ought to be met for that matter to be heard?
Is it, is it you said the application for leave to appeal?
Any application that is brought late to that court, because the test will be more or less the same.
As far as I know, remember, it's an application that's similar to a condonation application, and therefore the principles relating to condonation would have to be considered, which is obviously considering the degree of lateness, the explanation that is proffered for that lateness, the prospects of success in the matter, I think it's the balance of convenience, whether it favors the granting of that application.
All right, thank you. My second question is in relation to the judgment that you wrote in the High Court, KV versus WV. It's also in your question.
Yes.
That was dealing with domestic violence.
Yes.
I understand that you might not have it there, so I'm not going to deal with the actual, but something that arises out of it, where I need your input on it. One of the things that you mentioned in the judgment is in relation to the safety of the person who has been granted a protection order, and why that thing is important. I just want to ask you this question. In the magistrate courts, usually, we see interim protection orders in particular being used as an eviction order of some sort. In other words, and now that brings into play the challenge between the gender issues and the Section 26(1) of the Constitution, the right to housing. How do you think that first, is there a conflict between the two? And assuming that there is, how should we balance that conflict where somebody should be protected by making sure that there's an order that says the perpetrator of this thing should not be where this person is, but you find that the perpetrator's housing, it's where he or she is told to get out of. How do you balance that tension, if there is tension at all?
Well, I believe that there would be tension. Well, obviously not in all instances, because obviously in some of the instances where an order is made for somebody to vacate the house, they're able to leave and find alternate accommodation for, up until the order is either discharged or confirmed. But then I dealt with a matter where it involved two housemates. They're both renting in the same premises. And the order that was made was such that it still allowed them to live in the same premises Obviously, the enforcement of that is a challenge because if you're sending people back to the same house, and for instance, where there's this physical abuse involved, I think what was said in the judgment was sometimes the mere existence of the interim protection order would restrain the other person from breaking the law, but then it's not in all instances that would happen. And in some of the instances, it would even lead to dire consequences because now the person you actually took me to court and now you have an order against me, and then, somebody may just be killed as a result of that. So it is
I guess, sorry, Judge. I guess my question is, can you use an interim order, an interim, what do you put, protection order, to evict someone? I think that is the question that I'm actually asking. Can an interim protection order be an instrument that is used to evict somebody from a particular house? I think that is basically the nub of my question.
Is it evict as in temporarily whilst that order is interim?
Both temporarily or even permanently. Can we use an order that says this person on the interim has done 1, 2, 3, 4, 5, there must be a return date for this person to come to show why this order should not be made final. Then in order for us to enforce, yes, the enforcement issues might be, they might be worrying, but I'm not asking about that. I'm just asking from perhaps even on an abstract level, can or should, because we see this happening in the magistrate court almost every day. Is that something that should be happening? Perhaps maybe that's the question I'm asking, and I will leave it there.
I don't think it should be happening. But then I think what the court would be looking at is the risk involved in, the life of the person. Hence, I'm saying it would depend on the nature of the domestic violence that is involved in the instances. You can make an order and say the person can stay, but then where the risk is, or the harm actually is much more serious, I think you can do that.
Thank you very much. Thank you, CJ.
Thank you. Commissioner Singh.
Thank you very much. Good evening, Judge Masipa.
Evening,
I don't want to make the mistake of my colleague there. I think we're thinking about the last interview and when we're going to go to bed and have dinner. Thank you very much. In a previous interview, there was a complaint when you were an attorney.
Yes.
About a client coming in and you withdrew a matter and so on and so forth. I'm not going to go into the details. And we were told that the matter is being appealed by yourself.
Yes.
Has there been any progress with regard to that appeal?
The appeal was heard, I think, in February of 2021. And it was heard by 2 judges from, I think, the Eastern Cape. And they rendered a judgment a few months later and found that the decision of the Law Society was wrong, and they set it aside.
That's good to know. And I note that just reading at some of your judgments, your independent-mindedness, where you dissented in the dissenting judgment. There were 4 senior judges at the SCA, and you dissented. It was a matter about rugby and injury.
Yes.
Can you just lead us through that and what made you come up with a dissenting judgment in that regard?
Sorry, can I do?
Can you just take us through that case?
Oh.
And what in law made you dissent from 4 senior judges?
The matter involved the Minister of Education, where a schoolboy was injured at a rugby match. What had happened was that the school, it was an inter-school event, and he was not from that school. The school that was responsible for the events was responsible for arranging that there's proper care for, there was several sporting events happening, and that all the medical or the necessary first aid facilities were made available at that school. And the visiting school where the boy came from had gone to that school, and they went and also satisfied themselves that the requirements that they had were complied with. The boy was tackled. Okay, what had happened was, in terms of the procedures that were available at the time, that was, I think, in 2006, what was needed in order for a rugby match to take place was a stretcher and a neck brace, and access to medical care. It was not necessary, for instance, that there be an ambulance, but there was a need for first aid trained person to be present at the premises. So what the school did was that they engaged the services of a service provider who was providing services to, from what the evidence said, the whole of Potchefstroom, including the university. He was known, and because everyone was using him, they were booking him in advance, and the school had done that. They looked at his calendar and looked at their sporting calendar, and that indicated that we're going to have these events happening, and they booked him. In the morning of the event, checks were done, the stretchers were there, the neck braces were there. The match started, and the person that was responsible for the running of the match was, in fact, the referee. If the referee, the policy was the referee must satisfy himself that all the necessary tools are there, all the first aid yes, were there. And if he is not satisfied, then the game will not start. So he was satisfied that they were there, and the match started. This boy was injured, and they were supposed to remove him. Well, no, the referee indicated that he should be removed because he was taking time from the ground or the field. And they then, seemingly, there was no stretcher. And the service provider and his staff went and they lifted that boy, and he had apparently already sustained a first injury on the spine, and when they lifted him, because they did not put him on a stretcher, he sustained a second injury. They put him outside, and then they took him to the hospital. Obviously, he was very badly injured. So my issue was the role that the school, and by virtue of the position that the MEC holds, he is then the responsible person for the school, had done all that was expected of them to make sure that the necessary first aid services were there. That person was the only service provider who was known or who was being used by everyone in that area. So the difference that I had with the other judges was that they wanted to apply, or they applied, not wanted, the subsequent or later first aid, I'm going to say first aid care or requirements, which were in place at about the time that we're now dealing with the appeal judgment versus what was in place in 2006 when this child was injured. The requirements that they just needed to have a stretcher and the neck brace had since changed. It is necessary to have an ambulance and a whole lot of other resources, and probably even have a medical trained person at the field. So my issue was that we're supposed to be looking at what the position was at the time when this injury was sustained, what we expect that the MEC or the schools ought to have done at that time. And I think the other issue was that there was also an expectation that the school ought to have phoned them or communicated with the Health Professions Council to find out if this person was registered or not before they engaged his services. So in my view, everyone else was using him. So, my analogy was that when we all go to medical practitioners every day, we never inquire from those medical practitioners, I want to see your medical, your qualifications, I want to see your registration details with the Health Professions Council. We accept that they've been there, they've been providing services. If I'm sick and I'm going to see the doctor, he treats me, it's fine. I felt an unnecessarily onerous duty which was expected of the MEC to have gone and inquired or investigated from the Health Professions Council whether this particular person was registered with the council or not. Because in any event, it was not a requirement in terms of the SARFU rules which applied in 2006. In 2006, all that was required was a neck brace, a stretcher, somebody who is trained for first aid services, not even registration with the Health Professions Council. So that is how I differed with the other judges.
No, thank you. You're entitled to your view, but I think you know when any event is held nowadays, whether it's at a sports stadium or anywhere else, you have a safety officer that's got to ensure that there's compliance. I mean, you can't say, well, we've got an ambulance there and there's nobody in the ambulance and they don't know what to do, and we have a doctor there and the doctor is a fake doctor. But anyway, you made your judgment and you dissented.
No, but I want to explain, just please, can I explain? Okay. My issue was not that there was nobody liable for the injuries that were sustained by the boy. My issue was about the service provider. The service provider is the person who was responsible. He's the one that failed to provide all those necessary, the stretchers and whatever else that he needed to be there, not the MEC. And that was my issue. The MEC, in my view, had done all that he needed to do to ensure that the place was safe. The fact that in the morning, so secondly, the second person who was responsible was the referee, because as soon as the referee realized that there was a problem, he was supposed to stop the match. And he did not do that. And that is the reason why the Referees Association actually settled that matter, because in their view, there was clear issues of negligence which were visible. The service provider didn't even defend the matter. He did nothing. He just let it run. And I think there was not even any judgment that was granted against him, despite the fact that he was in fact the negligent party.
Chief Justice, just one more. In that same interview, you said that male lawyers at that time are generally dismissive of your abilities. Has that changed over the years?
In the courts that I work in, no, it has changed. I've seen a lot of respect coming from them, but then it's like a subtle thing that you feel, but you can't put a finger on it.
Thank you, Chief Justice. Thank you, Judge.
Thank you, JP.
Thank you very much, Chief Justice. Good afternoon, Judge Masipa.
Afternoon, JP Mnam.
I'm just going to ask you about the one judgment you discussed with Deputy President Betze, the one you say you co-wrote with Justice Govan.
Yes.
Is that the matter that related to the panel lawyer dispute between the RAF?
Yes, that's correct.
Right. Am I correct that when the roster came out, that matter was allocated to yourself?
Yes, that's correct.
How long did that matter, that judgment take to come out?
I cannot recall offhand, but it took quite a bit.
What?
It took quite a bit of time. I cannot recall. I have not looked at the...
Yeah, well, it wasn't delivered in the term it was heard.
Yes.
And it was not delivered in the next term. It was delivered in the third term from when it was heard. Am I correct? I'm not there. You are there.
No, I don't recall. I think I don't want to respond and say something. I did not check the time, and
But it took some time. No?
yes, I did say that.
My last question about this, CJ, is as a judge, you say this year is your 8th year as a judge. Did I understand
Yes.
you correctly?
That's correct.
You are acutely aware that in the first instance courts, there are certain matters that go on appeal that we look and watch and wait because we want guidance as first instance courts.
Yes.
Isn't this one of those matters?
I think at the stage when that matter was heard, it had actually gone beyond that. In fact, one of the issues that had to be dealt with was whether the matter was moot or not, because what was being sought to be appealed against had about lapsed. The order had, I think it made reference to the fund doing something within a period of 6 months, or there was a specific period that was given by the judge from the High Court. At the time when the appeal was heard, that date had already passed.
I see. Yeah, I know there was Section 18 processes.
Yes, there had been a Section 18 application,
Yeah.
but that was not what we were dealing with.
Yes. Okay. You say it took a bit of time. You know, my experience when I was in that court, we wrote judgments in the same term we got the matters, and we had the matters. Let's say I'm wrong that it was delivered in the 3rd term after it was heard. Some of us frowned when we saw the matter going over to the next term.
Yes.
And we wonder why. Now, can you explain, because you say it was allocated to you, you say it took a bit of time. What was the reason? Was it a complex matter?
Well, and this is not the only matter in respect of the comment that I'm going to be making, is that some colleagues don't comment, they just keep quiet, and you've circulated a judgment and no one comes back to you to say anything. And then you have to follow up and follow up and follow up, and so I think towards the end of the term, that's when Judge Govan was about to be leaving. Then I spoke to him about it, and that's when he then said, I'll have a look at it. And I think it was, in fact, about a day or two before we're leaving. That's about the first time that I had a comment from one of the judges that were there.
I see. CJ, thank you very much. I don't want to prolong this one. Thank you.
Thank you. Commissioner Moimang, you are covered. Thank you. Commissioner Barnett. You are covered.
No.
Okay, go ahead.
Thank you, Judge Masipa. I just want to confirm, first of all, the comment that you had in respect of the appeal that you had against the Law Society of KZN. So, Justice, I don't know, on my side, there seems to be quite a big echo.
Yeah, you are breaking, kind of. Maybe just start again, let's see.
Yes, first of all, I just want to confirm that I have read the full judgment, and I agree with you fully that, the court had found that you acted totally under pressure situations in the best interest of your client, and that the conviction by the Law Society was wrong. So I just wanted to confirm that I had read that judgment in full. It was thanks to the Secretariat for sourcing that for us. What I would like to ask you about is the John Wesley School judgment, and not so much about the principle involved, which is a constitutional principle and which you've already referred to. My question is specifically in relating to the costs. You'll notice in the order on page 28 of the bundle, if you do want to refer to it, there's no order as to costs in that matter. And I think costs are not discussed anywhere in the judgment. Sorry, I'll give you an opportunity. Page 28. Paginated page.
Yes. Yes, oh, you
Right.
said the order.
Yes, so the order is on page 28.
Yes.
And if you just turn around the next page, the question that is asked by the respondent, or the praise of the respondent, in praise C, the respondent, at least the applicant asks that the respondent be directed to pay the costs of the application.
Yes. Yes, I see that.
Did you follow that? All right. And yet, in the rest of the judgment, there's no discussion of the costs. There's no reasons given why there's no cost order, and eventually you make the finding on the principle, but you don't deal with the cost at all, or give an explanation of why you are not dealing with it. So I was wondering if you could comment on that, please.
Ideally, the issue of cost should obviously be addressed and be dealt with in a matter, but where there's no cost order made, the fact that the judge has not dealt with that or reflected it does not mean that it was not considered. But I take the point, and ideally, in the other judgments that I deal with, I will, make a closing paragraph to address the issue of costs.
In fairness to you, this was a 2018 judgment, and the latest judgment we have dealt with costs.
Yes.
Thank you very much, Judge. Thank you, Chief Justice.
Thank you. Deputy President of the SA. You.
Thank you, Chief Justice, for indulging me. Judge Masipa, in relation to the road accident fund case that the Judge President indicated to you that took long to be delivered, did you at any stage approach the judge who was the presider to express your frustration at the fact that you have circulated a judgment in good time, and the other members of the panel were not forthcoming with their comments or suggestions? Or if you didn't get joy from him, approach me, as I indicated to you, that if you had any challenges, don't hesitate to discuss those with me.
Sorry, I'm quiet because I'm trying to recall. I did speak to him. I cannot recall if I spoke to him after I had spoken to Judge Govan, because I remember indicating to him that Judge Govan is looking at, I had spoken to him and was looking at the draft, and then he said, let's wait and see what Judge Govan comes back with. But I think it was after I had spoken to Judge Govan.
Thank you. In your list of judgments that you consider as significant, you have the Kwafel Close Corporation case, where in the narration at page 14 of the bundle, you say that the parties were agreed that the matter was moot, and you similarly formed the same view. Shouldn't that then have been the end of the matter?
Yes, in fact, to me, that was the beginning and the end of the matter, because I actually, when the matter was being addressed in court, was the one when counsel sought to deal with the merits of the case that I said to him, in my view, we should, and please address us on the issue of mootness, because that's the main issue that would bring this matter to finality. I don't recall, is it the one that I said I'm dealing with that, but in the event that I am wrong, then I dealt with something else?
In your narration, I cannot discern why you consider that case to be significant. The parties tell you it's moot. You also accept that. So that should have been the end of the matter. The appeal should have been struck from the roll. And yet you proceeded to deal with the question of the court order that had been made by the High Court. The judgment itself commences at page 63.
Yes, I'm actually looking at that.
Are you looking for
Yes, sorry,
an
Chief Justice, I was,
explanation?
sorry, apologies. I was just trying to get to that point. There are instances where a matter is moot, but that there's some issues that remain live that would need to be addressed. This would have been the reason why, because of the seriousness of us leaving this matter and not attended to, that we proceeded to deal with the issue of costs.
But the focus of my inquiry was that you found that the matter was indeed moot and that the interest of justice did not dictate that you should nevertheless deal with the merits. And that once you came to that conclusion, that should then have been the end of the matter.
Yes, I take note of that, but for some reason, the three of us seem to have agreed. I see that it ought to have been that way.
Thank you.
Thank
Thank
you,
you, Chief Justice.
Thank you. I think we have come to the end of the interview. Thank you very much once again for availing yourself. You are now excused.
Thank you. Thank you to everyone.